everyone. Welcome to the J6 webinar series on the 27th of May 2021. Thank you very much for tuning in to this webinar. We're going to cover two topics today. Firstly, I'll be talking about disqualification and driving offences, and then my colleague Francesca Kirby is going to discuss the Police Crime Sentencing and Courts Bill, which is currently making its way through Parliament. In terms of the format of these sessions, we run them for the benefit, we hope, of junior solicitors and practitioners, and hope to pick topics that they are interested in and that are relevant to their practice. And we hope the talks today will fit that criteria. They're informal sessions, so please feel free to ask questions or raise your hand, and we'll do our best to catch them. And if not, please feel free to get in touch by email with any questions about the talk that you have, and we'll endeavour to answer them in a timely fashion as well. So without further ado, I think that's all the housekeeping I'm obliged to do. And so I'm going to proceed with the talk on disqualification. So firstly, this is an overview of the session today, the first half an hour. We're going to look at the types of disqualification, firstly, that are available to the court. That can take the form of an obligatory disqualification, where the court must disqualify your client. And that can either be for a specific offence or as a result of accumulation of penalty points. Then I'm going to talk about discretionary disqualifications, firstly dealing with instances where discretionary disqualification applies for section 34(2) for specific offences. And then we'll have a little look at the more broad powers that the court has under the Sentencing Act, provision 163 and 164. And although they're in the Sentencing Act, they're not new powers. They were formerly in the Powers of Criminal Court Sentencing Act 2000, but have been merged now and consolidated in that act. And then in the second half, I'll look at what options are available to defendants and clients where they face a potential disqualification, and what they can do before the decision is made to either prevent disqualification entirely or to reduce the term of disqualification which is imposed. And then there are also certain circumstances where even after a disqualification has been imposed, if it's been imposed for a particularly lengthy period, more than 2 years, then they can apply to the court after a certain amount of time has elapsed to have it removed. And we'll talk a bit about that as well. So without further ado, I've included this quote here from a very recent case of the Crown against Thomas. I've included it for two reasons. It's a recent cautionary tale, but it illustrates, I think, the difficulties which sentencing driving offences really can provide for both advisors and for judges. It's not easy to get the provisions that govern these powers correct, and I hope this case will also illustrate the importance, secondly, of understanding the provisions well, and I hope that today's webinar is going to hopefully do that for us. So turning first to consider obligatory disqualification for specific offences. That power is governed by section 34 subsection 1 of the Road Traffic Offenders Act 1988, and it's fairly self-explanatory, as you can see on the screen. If you're convicted of an offence that carries obligatory disqualification, then the court must order you to be disqualified, and the period for which they must order your disqualification is not less than 12 months. That power is exercisable unless the court feels there are special reasons which they should not automatically disqualify you, and we'll come to those later. So what is an offence involving obligatory disqualification? Well, that definition is found in section 97 subsection 1 of the same act, and helpfully that will direct you to schedule 2, of the same Act. And there's a big long list there of driving offences, which you'll all be pleased to know that I will not be going through one by one. But suffice to say, they're many and varied in their nature. And for an example, a few examples would be driving with excess alcohol, driving whilst unfit through drink or drugs, or dangerous driving. The simplest way to check if your offence is caught by an obligatory disqualification provision is the sentencing guidelines, which are very clear. And I would advocate going to that first. A couple of important points. First, pursuant to section 46, subsection 1 of the same Act, disqualification, obligatory disqualification will apply even if your client is given an absolute or conditional discharge. Further, if the court disqualifies, there are no penalty points to be imposed in respect of that offence, nor are there any penalty points to be imposed in respect of offences that he is convicted of on the same occasion as that which a disqualification is ordered. And the long-standing authorities of Martin and DPP and Ahmed and MacLeod are authority for that point. Recently, the point has been reiterated in the Crown against Fisher and the Crown against Thomas. But interestingly, I note a different use of language. The language used in Thomas is certainly that the offence does not fall to be endorsed with penalty points if it was committed or perpetrated on the same occasion. Whether that is a material jump remains to be seen, but it is certainly it is a different distinction in language, whether or not that was intended. If the court does not disqualify, it must endorse the licence and impose penalty points, finally. So how long will your client be disqualified for under section 34(1)? Well, the Act provides for minimum periods, but no maximums. And we have to turn to case law for general principles which guide the period of disqualification. Firstly, it should be for a specified period, not an indefinite one. And the court should decide on the period of disqualification which is appropriate to the facts of the case. So there's a broad discretion for the court to take into account all of the circumstances in determining what is the appropriate length. Increasingly, however, it's the policy of the Court of Appeal to discourage disqualification for life or for very long periods, in particular where defendants are young. Indeed, it has been described as wrong in principle previously. The Crown against Needham also illustrates that a balance needs to be struck between the competing public interest in protecting the public by virtue of a disqualification, and also the need and intention of the provisions to punish and deter offenders. But again, we have to consider that against the background of a defendant and the effect that a disqualification has on people's lives. It should be no longer than necessary is an important point and a factor to draw attention to the court. And finally, another important point to realise is that credit for guilty plea will not apply to the driving disqualification order. The guidelines on guilty pleas are very clear. It only applies to the punitive element of the sentence and does not apply to ancillary orders such as driving offences. So calculating the relevant minimum period is another exercise that one must go through when dealing with an obligatory disqualification. The minimum period is 12 months, but there are greater mandatory minimums for certain offences or sometimes where the defendant has been previously disqualified. It will be 2 years if the defendant commits any of the offences that you see in section 34(4)A listed there, or if the defendant has been subject to 2 or more disqualifications which were longer than 56 days within the 3 years immediately preceding the commission of the offence. But note here, for the purposes of the exercise at B, you would disregard interim disqualification or disqualification where the vehicle was used for the purposes of a crime. Interestingly, not the broader power which we'll come to under section 163, but also you would disregard disqualification for stealing, taking a vehicle, or going equipped to steal or take one. Where it comes to the heightened term of 3 years, that's governed by section 34, subsection 3. And this is a conjunctive test rather than a disjunctive one. Where the defendant is convicted of any of the offences in subsection A there, and they have been convicted of any such offence within the 10 years immediately preceding the commission of the offence, then that will attract the heightened disqualification period of 3 years. One important point that I would raise at this juncture is that it's important to be on top of the specific offences that your client's charged with, or that are contained within the antecedents. And it may seem an elementary point, but it is one worth reiterating, because as you'll see from the failure to provide a specimen offences or to allow it to be submitted to a lab test, that only catches the 3-year provision if it's where the defendant has been suspected of driving or attempting to drive in the underlying facts. It doesn't apply to the offence of merely being in charge. And so elementary that may be, it is worth just reminding ourselves of these distinctions. Coming then to the penalty points disqualification. Again, fairly self-explanatory. The court must order the defendant to be disqualified for not less than the minimum period if the defendant is convicted of a relevant offence, and that offence means he has more than 12 relevant points on his licence. The key here is to decode what is a relevant offence and what are relevant penalty points. So a relevant offence is one either that involves discretionary disqualification and obligatory endorsement, or one that involves obligatory disqualification but where no order is made under section 34. It does not apply to some construction and use offences, and they are using a vehicle in a dangerous condition or breach of requirements as to brakes, for example. But that is only the case if the defendant proves in relation to those offences that he did not know and had no reasonable cause to suspect that the facts of the case were such that the offence would be committed. So these are your must endorse, may disqualify offences, as they are sometimes referred to by legal advisors and benches. And again, you would look for those in Schedule 2 of the Act. The second question, which I referred to briefly earlier, is which penalty points are relevant penalty points? And the phrase used often in the legislation is to take them into account. So penalty points will be taken into account where they're attributable to the offences convicted of on that occasion, or that they are previously endorsed on the licence, save where between the time that the previous points were endorsed and before the conviction, if the defendant has been disqualified under section 35, they won't count. So then we turn to matters which the court won't consider. Any offence on that occasion where section 34 disqualification has been imposed, and penalty points will not be added together where any of the offences in respect of which points were imposed was committed more than 3 years before another. So there's an arithmetical exercise to be done here, and also keen focusing on dates within the antecedents, which needs to be undertaken. The effect of the provision section 29(1), which governs the points which will be taken into account, is that a defendant's slate will be wiped clean where he is convicted under section 35, and the points will no longer, on a future occasion, fall to be taken into account by the court for the purposes of totting. But it won't be wiped clean where your client is disqualified under section 34. For example, a person who has 6 points on their license and then is disqualified for dangerous driving under section 34, say they receive a 12-month disqualification. If they then are back on the road and they commit an offence of no insurance, then they would still be liable to totting on that occasion. Again, an important case here is the case of Brentwood Justices, and that specifies that on that occasion, i.e. the court, the time when points fall to be considered is the date of sentence and not the date of conviction. And in Brentwood Justices and Richardson, what happened was the defendant had, between his conviction and sentence, been subject to a section 35 disqualification. And so when it came to his sentence for the offences which had been adjourned, he had a clean slate and was no longer subject to the totting requirements, to the totting provisions. So how do we calculate the period of disqualification for a section 35 disqualification? Well, the starting point is that the court must take all the offences on that occasion into account when determining a disqualification period. But then we see there are also minimum periods as for section 34. There are also minimum periods imposed here. And you can see there that it will be 6 months if no previous disqualification is imposed on the offender, which is to be taken into account. 1 year if one is to be taken into account, and 2 years if more than one. Again, we have to ask ourselves a question of what is a previous disqualification which needs to be taken into account. And that's to be found in section 35(2) of the Road Traffic Offenders Act. It was, if it was a disqualification for 56 days or more and was imposed in the 3 years preceding the commission of the latest offence, then it will need to be taken into account. It won't be taken into account if the period of it would have been less than 56 days, but for an extension period due to the imposition of a custodial sentence. And I should say here, we're not going to be able to touch on extensions for custody or indeed retests or extended retest provisions, because there simply isn't time and they're involved in themselves. But perhaps that will be another talk in future. So continuing with the period of disqualification for section 35 then. Disqualification does not include, in this context and for the purposes of what is a relevant disqualification to take into account, interim disqualifications, disqualifications for the use of a vehicle in an offence, or a disqualification imposed for stealing or taking without authority, etc., as was discussed previously as a mirror provision. Then we can turn to discretionary disqualifications for specific offences, and that is governed by section 34, subsection 2. The court may order disqualification for such a period as it thinks fit, where the person is convicted of a offence involving discretionary disqualification and either fewer than 12 penalty points are to be taken into account, or it's not an offence involving obligatory endorsement. Again, we look to Schedule 2. To give you a flavour, I won't go through them all, but examples of the types of offences which will attract discretionary disqualification are being in charge with excess alcohol, being in charge whilst unfit through drink or drugs, and careless driving. Again, the court must either endorse with penalty points or impose the disqualification period it thinks fit. One difficulty with this provision is that the circularity of section 34(2). Whether or not the court has the power to disqualify in these circumstances depends upon the points to be taken into account, but the number of points to be taken into account depends on whether or not the court disqualifies. The solution to this problem is Jones and DPP, and the court there described the process that one should go through. And it's for the court first to consider a discretionary disqualification under section 34(2) in light of the offender's record. And if the court comes to the conclusion that because of the offender's record, he should have a longer disqualification than would have been justified on the facts of the disqualifiable offence alone, then the course the court should adopt is to not disqualify him discretionarily under section 34(2), but subsequently to render him liable to the section 35 disqualification provisions. So other discretionary powers of disqualification. The first one and the broadest one is section 163 of the Sentencing Act 2020. And that is that the court may disqualify an offender convicted of any offence as long as it's committed after the 1st of January, whether or not it deals, 1998, whether it deals with the offender in any other way or not. That is a broad and far-reaching power available to the court, and one which we'll perhaps see from the case law that we're about to look at, that is not often used or not used as much as it perhaps ought to be in certain tricky situations. There's a broad discretion here, and it seems unusual when judges plump for more technical provisions, as we'll come on to, when it could simply disqualify under this very broad power. But the significance of it is important because, as we discussed earlier, authorities such as Cully, which suggest disqualification should be no longer than necessary, are said not to apply to that power. And so that potentially leaves the court with a very, very wide ambit indeed. The next discretionary power to look at is section 164, subsection 1 of the Sentencing Act 2020. And that is the power to punish for an offence where a vehicle is used in the commission of a crime or to facilitate the commission of a crime. It's not as broad as section 163. Indeed, there are numerous qualifying criteria. The defendant has to be convicted on an indictment, and the offence has to be punishable with more than 2 or more years in prison. But the power does extend also, not just to the facilitation and commission of crimes, but also for the use of a vehicle to dispose of any property relating to the offence or to avoid apprehension and detention or detection. You see also that the power is extended to various offences of assault as well under section 164(3). The interesting, in my view, illustration of these two competing powers comes in the context of conspiracy and the case of Gorey. Gorey was a case that concerned a conspiracy to burgle dwelling houses and a conspiracy to steal cars. The judge in Gorey purported to disqualify the applicants under section 147, as it then was. So the power to disqualify where a vehicle is used in the commission or facilitation of a crime. rather than section 163, the general power. And the court held in Gorey, reiterating the former case of Riley, that the only circumstances in which a conspiracy would lend itself to the power in section 164 was where the vehicle was used directly in the formation of the conspiracy itself. Here, that was clearly not the case on the facts. And the reasoning for the principle is clear. The overt acts demonstrating or executing rather a conspiracy are simply the evidence from which the conspiracy is inferred. And further, admitting guilt to a conspiracy does not in itself lend itself to the accused having admitted acts that are averred by the Crown in furtherance of it. And we can contrast this case with Langley. Langley was a case where it was argued that Riley and the principle in now Gorey applied. Essentially, the conspiracy to rob, of which this appellant was convicted, meant that the vehicles were not used directly in the formation of the conspiracy itself. However, the court pointed out here that section 164.2 clearly applied on the facts. And in this case, the applicant was the getaway driver for these robberies. So he was using his vehicle for the purposes of avoiding apprehension or detection, and therefore the conspiracy charge was caught and the imposition of a disqualification was lawful. The cases that we've just talked about are important because it illustrates the importance of using the correct power to disqualify. Arguably, two further cases are important as well when it comes to looking at whether the Court of Appeal will substitute or interfere with decisions where the wrong power is used. In Cox, the appellant was convicted of possession of offensive weapon, which he had on him during a road rage incident, and the judge disqualified him from driving. It was unclear, though, from the transcript, which power was used. Was it section 164, which related to the commission of the crime, or was it the general power in section 163? If it was the former, the court was not entitled to exercise that power on the facts, whereas if they'd used the broader power in section 163, then the court would have been entitled to disqualify. The reason for the ambiguity arose because once prosecution counsel had highlighted the power in section 163, the judge repeated back to him, yes, connected. It was a very short transcript, but it cast doubt and it suggested that the judge had used the power based in 164. But what the Court of Appeal did was they reasoned their way out of interfering with the decision of the judge in that case by saying that they thought it very unlikely that the court would be unaware of their general powers and did not really believe that the judge thought the appellant was driving his car for the purpose of committing or facilitating the commission of possessing an offensive weapon. So they managed to avoid having to interfere with it, the power that was used there, and inferred that the court was in fact using section 104. They made no decision about which power it was using, but they seemed to allow it to stand. And then we come to the Crown against Peters, which is more recent. The appellant there had been convicted of criminal damage by driving into the victim's car and shunting into the garage doors. The court disqualified and endorsed the license for the other offences which the defendant was convicted of, no licence and no insurance. And it was unclear if the appeal court whether the judge had disqualified under section 34 as a discretionary disqualification or under section 35 as a totter. Again, the former was available and the latter was not. In the circumstances, what the Court of Appeal did was they substituted whatever purported power the judge at first instance used with what is now section 163, the general power, and attached it to the criminal damage offences. And therefore, despite the imposition of an unlawful disqualification at first instance, the court then decided to impose and exercise discretion, or found that no doubt the court would have been entitled to exercise that discretion at first instance, and they so did on appeal. So again, the importance of identifying the correct power, particularly at the time, is very important. Some procedural considerations. The court must not disqualify in absence if proceedings are started by summons or requisition, unless the court has adjourned the case and given the offender notice of its intention to disqualify. Perhaps one relevant more to the prosecutors in the room, that the court may, instead of disqualifying an offender in absence, issue a warrant for the offender's arrest. Plainly, for a driving offence, that's not the position we want to be in if we're defending, but nonetheless, that power does exist. We can see there a couple of cases in relation to the question of adjournment. In this instance, where the court lacks information to make an informed decision on totting up, plainly the correct course is going to be to sentence for the punitive aspect and then adjourn the question of disqualification. Turning to options for redress, the first exception to imposing disqualification is special reasons, and that applies to obligatory disqualification and endorsement. So the court can only choose not to disqualify in an obligatory situation where there are special reasons. A special reason is something special to the facts of the offence and directly connected with the commission of the offence. It's got to be distinguished from something that is peculiar to the defendant. A special reason must be a mitigating or extenuating circumstance that doesn't amount to a defence in law, and one which is connected to the offence and which the court ought properly to take into account. I've listed a few cases there. I'm not going to go through them all for the strictures of time. However, what they show is disagreement about the nature of special reasons, particularly in the context of triviality. Smith and Henderson suggest that triviality can amount to a special reason. Nicholson and Brown, Lord Widgery disagreed. Again, Delroy Hall and Tadman disagreed with that sentiment. But then Marks and West Midlands Police suggested that the fact that an offence is small in nature or minor in nature can't be totally ignored. The key point I want to make here is what to make of these decisions, and that is that it's difficult to discern a coherent set of principles about the court's approach to special reasons. And so this, the only real way is to reason by analogy to existing authority to establish that a special reason exists. And this is really where I would say counsel particularly can add value, particularly if you are a busy solicitor with a considerable caseload. This is an area which is research heavy, and again, as I say, somewhere where a counsel can add value who has perhaps more time to engage in lengthy legal research in relation to these points. Turning then to what will and will not amount to a special reason. Some of the discrete circumstances are detailed here. So the shortness of distance driven is often cited, particularly where it's in the context of the defendant being unlikely to be brought into contact with another road user. That the offence was unintentionally committed, or that the defendant was misled without negligence into committing it. That particularly pertains to things like insurance offences, where defendants believe they're insured and have taken reasonable due diligence to ascertain that. And then it subsequently turns out that the offence and insurance has been committed. Regurgitated alcohol is another discrete area where special reasons have been found to exist. And the fact that the defendant committed the offence whilst coping with a true emergency. But what won't amount to a special reason is anything to do with the defendant himself, or his personal circumstances, or his character, no matter how severe. The fact that the defendant has employment, for example, is a doctor with a public benefit to his job and needs a license to execute his duties, won't count. The particular case of Kwame is a proposition that the fact that a condition of bail renders a defendant unpermitted to drive doesn't amount to a special reason. And we come back to the debate of Nicholson and Brown and Delroy and Hall. The fact that the offence was trivial, on balance, it's probably not going to be a factor, as is indicated here, that amounts to a special reason. A few discrete points about special reasons. The burden of proof is on the defendant. The balance of proof, the standard of proof is the balance of probabilities. Finding special reasons merely creates a discretion. The next question is going to be, if they are found, to persuade the court not to impose the minimum or not to endorse. It's unlikely to assist in any event in cases of seriously bad driving or very high alcohol consumption. Therefore, the court will frequently take the view that it's tough, and even though there may be a special reason, they are not inclined to exercise their discretion in those circumstances. And there are clear public policy reasons why that may be the case. The need for evidence is also key. It must go beyond mere assertion by advocates, and it must be admissible evidence. We're all used to the new procedure rules in criminal courts, which require early identification of issues. But clearly, this on the case law is a particularly important point for defendants and their advisors in these types of cases, and has been throughout the case law, not just since the reforms to the way the criminal courts work. And that's particularly the case where there's a suggestion that the defendant has been laced, had their drink laced. Again, a couple of formalities. Where special reasons are found, they must be stated in open courts, and it should be entered in the magistrate's register. So next, we come to mitigating circumstances, and to avoid a totting disqualification, the defendant will often have to prove the existence of mitigating circumstances and then again persuade the court to exercise them. Similarly, the burden is on the defendant to prove this. The standard is again the balance of probabilities, and evidence is likely going to need to be called. Two discrete cases there. Imposition of custody as well as disqualification can mitigate the ordinary consequences, as well as the need for the defendant to be rehabilitated. Section 35(4) prescribes certain things the court must not take any account of. The first of those is any circumstances which are alleged to make the offence or any of the offences which they are convicted of not a serious one. Hardship other than exceptional hardship should not be considered, and often defendants will be arguing exceptional hardship, and frequently that's the ground that comes up. And finally, defendants can't argue anything which in the 3 years immediately preceding the conviction have already been taken into account by the court in ordering either a shortened period of disqualification or not ordering him to be disqualified at all. The difference here in the wording of Section 35 with Section 35(2). Section 35(2) provides that the minimum period of disqualification is increased if a previous disqualification was imposed within the 3 years immediately preceding the commission of the latest offence. Section 35(4), as we can see there, relates to the 3 years immediately preceding conviction. Now, perhaps an unscrupulous defendant may endeavour to delay his conviction for an offence pursuant to Section 35, so that he can then try to get outside of Section 35(4)(c) and argue circumstances which have previously been put forward. But I think perhaps the bigger problem is going to be for defence advocates is how you prove, given the limited nature of record keeping in magistrates' courts, what the circumstances put forward on the previous occasion were. Often entries into the court register may not reflect perhaps subtleties, which defence may then want to argue create a new change of circumstance that hasn't previously been considered. And that's very much the defendant's problem, and it's the burden is on the defendant to show that the circumstances being put forward are in fact new ones and should be accepted by the court. Points of good practice would be to obtain a copy of the court register, and you can also try to prove that it's not been taken into account before by calling evidence, of course. Some miscellaneous redress available to defendants. There's a power to suspend pending an appeal, reduction for attending courses, particularly in relation to drink driving, although there is power that's not included here, which may be brought into force at a later date that would apply that more widely to offences that don't relate to alcohol. But it's not in force yet, which is why it's not included. The court shouldn't disqualify if this is a case where there's a guardianship order or a hospital order made, because there's not strictly been in circumstances under the Mental Health Act, Section 37(3), because it's strictly not a conviction. And then we can see here in the second half of this slide the circumstances in which the defendant may apply to make an application to remove his disqualification. Whether or not they can do depends on the length of time for which the disqualification is imposed. You can see the various periods there, and also below it, the circumstances which the court will take into account when considering whether or not they will grant such an application. Suffice to say that a person disqualified for 2 years or less can't apply for removal, and the only recourse is therefore to appeal to the Crown Court in hope of a reduced period of disqualification. And that's all we've got time for. So thank you very much for listening. And I'll endeavour, I can see a few things popped up in the chat, I think, so I will endeavour to see to those. And I'll now hand over to my colleague, Francesca.
Hi, everyone. I'm just going to share my screen for my PowerPoint presentation. Thanks to Tom for giving his. I'll try, I'm just conscious a little bit I'll try not to keep you too long this evening, but effectively I've got 3 points which I'm going to talk about in my presentation. So moving therefore on from driving to a completely different topic, we are going to talk now about the new police crime sentencing courts bill. I'll just get rid of this because I think everyone can see that's better. So effectively, what I'm going to be talking about today, I'd like to just extend my thanks to Tim Kiley, who provided some additional notes for my presentation. And this bill has been introduced to the House of Commons on the 9th of March 2021. It's very recently had its second reading on the 15th of March 2021, and it's now at the committee stage. The bill itself is quite a mammoth piece of legislation with many controversial parts, and it's something as practitioners that we all should be concerned about. I'm going to focus on three of the most controversial aspects from a practitioner's perspective, and those are going to be effectively pre-charge bail, changes to public order and protests, and knife crime and the introduction of serious violence reduction orders. There's much more within the bill. As I say, it is a bit of a mammoth piece of legislation. So these aren't the only controversial aspects, but certainly I think they're three of the key ones for us. So beginning therefore with pre-charge bail, it's exactly what it says on the tin. It is bail given to re-attend a police station following arrest but pre-charge. Conditions can be imposed to prevent the suspect from failing surrender, offending on bail, interfering with prosecution witnesses, or otherwise obstructing the course of justice. It's different than being released under investigation, a topic that we will briefly cover. And in fact, the proposals by the new bill effectively are to try to tackle the amount of people who've been released under investigation when in fact they should potentially have been on pre-charge bail. There I put up three key provisions for bail for the current regime. I'm going to focus mainly on detention in police stations. Effectively, the detention in police stations and the arrest elsewhere at a police station they are largely comparable. And in order to give some context, it's also important that we talk about the Policing and Crime Act. The Policing and Crime Act in 2017, up until this point, there had actually been no statutory time limits for the time which a person could be subject to police bail, including bail conditions. And the principal aim of that act was to ensure and reduce the number of individuals subject to and the average duration of pre-charge bail. It aimed to provide a presumption for release without bail, with bail only being imposed when it was both necessary and proportionate, to set clear expectations that pre-charge bail should not last longer than a specified period, and that limit at that time was 28 days, and make provision for when the initial period might be extended, and also have an exceptional case procedure. So therefore, speeding through this, preconditions for bail, effectively, you can see it's left pretty wide, section 50A. A custody officer needs to be satisfied that releasing the person on bail is necessary and proportionate in all of the circumstances. Pre-charge bail itself, these are the duties of the custody officer before charge, and it's effectively, there's an ongoing duty. If the custody officer determines that he does not have such evidence, the person arrested must be released. So that's where we see the presumption of release without bail as must be released comes first. Moving on to the next slide, this is where this deals with where it's released for another purpose, and you can see 37.7a is in relation to a charging decision. Or if release is for another purpose and the preconditions for bail are satisfied. Such a release would be without bail otherwise, so that deals with the decisions. The current time limits, that's 47ZB, and you can see here that in an SFO case, it's a period of 3 months, but in an FSA case or FCA case, sorry, and any other case, the period is 28 days. So that's where we see the 28 days limit that has come in. It also should be noted, although it's not on this slide, the running of the applicable bail period is suspended where the release on bail is awaiting a decision of the DPP. It's not just limited to 28 days. You can see here that a decision maker can extend, and they can extend it provided that a number of conditions are met. Those are A, B, C, and D. Reasonable grounds for suspecting a person to be guilty of the offence, reasonable grounds for believing that further investigation is needed or further time is needed for a decision as to charge, reasonable grounds for believing that the investigation is being conducted or the decision or charge is being made diligently and expeditiously, and reasonable grounds for believing that the release on bail is necessary and proportionate. Effectively, a decision maker is a senior officer. Then moving on to this, they can effectively, this is where we get given the time in subsection 2, and you can see that a senior officer can effectively extend that period up to 3 months. And again, there are different provisions for SFO cases, and it has to be a qualifying prosecutor, needs to be again satisfied with conditions A to D, as we see there, and they can effectively extend it up to 6 months. After that, you can effectively only extend if you go to a magistrate's court. Again, they need to be satisfied of the conditions B to D that we've seen on this stage, and they can effectively extend it up to 6 months. And if their court is satisfied the nature of the decision or further investigations require longer, the court can then grant an extension to 9 months and 12 months respectively. So there's a step up effectively. So moving on, therefore, the one thing I just want to talk about what the proposals are going to be is pre-charge bail is sometimes described as a bit of a toothless provision, and this was quite interesting to me when I was looking at it, because obviously actually breaching pre-charge bail is not a separate offence in itself. So all the police can actually do is arrest you, and then they can either re-bail you on conditions if they can't charge you, or they can charge you. So effectively, this was part of the criticism. However, as we'll go on to see, the actual bill doesn't really deal with anything to do with this, and it doesn't strengthen up any of the aspects of pre-charge bail. So again, it still remains a little bit of a toothless tiger, as they call it. So the main critiques of the current system is that the police were circumventing the system for pre-charge bail and effectively releasing under investigation to avoid any of the time limits. There are concerns that the time limits and timeframes were not long enough for the police to investigate, and also people being left unprotected. So the government obviously launched a consultation, and they received a response. I put this up on the slide purely because it's interesting, because you can see that the majority of responses was from the police force. And of course, given that the police force are dealing with lack of funding and lengthy investigations, they're of course much in favour of extending these time limits. So if we move on to what the changes are, these are the proposed amendments. So we can see, firstly, the main change is the removal of the presumption against pre-charge bail. So you can see here from section 37, applies when a custody officer believes he does not have enough evidence. The removal of the keywords "shall be released without bail" and the substitution for "must be released on bail if the preconditions are met." So the legislation effectively completely flips with a huge emphasis change. And we can see here that when we are dealing with this, it's completely opposite to the standards that we apply within a criminal court. As for time limits, this is, apologies, that's the "shall be released without charge and if the preconditions are satisfied on bail, but not for the purpose mentioned in paragraph A." So this is dealing with the decisions of the DPP. So that's just a separate slide I've put in there. So proposed amendments, this is just a small change to start off with in relation to, you can now see that it's no longer just a serious, the FSA case below. So they've changed it now. So in an FCA case, HMRC case, NCA case, or an SFO case, the period has now changed to a period effectively of 6 months. And then in any other case, you can see now, so the standard cases, it's 3 months. So effectively, the period is widened for the cases that they deem to be more complex or serious, and any other case is now 3 months. There's Again, it doesn't stop there with the 3 months. So the extensions, you can see, it's now no longer a senior officer who can extend, but it's now it's a relevant officer, and a relevant officer is defined as a police officer of the rank of inspector or above. The relevant officer can now make the decision to extend to a period of 6 months. So it's 6 months now before a person even gets before court and they're subject to bail conditions. The extensions, unfortunately, don't even stop there, because we have two entirely new provisions on extensions. And effectively now, a officer with the rank of superintendent, provided the period is not ended, can extend to a total of 9 months. And in non-standard cases, it's 12 months. So it's 9 months in total that someone could be on pre-charge bail before even getting and stepping inside a courtroom. Of course, there has been, that's the non-standard cases, so the 12 months that I mentioned. There have, of course, been considerable response and concern to this. You can see a few quotes that I've put up on this screen, mainly that 9 months is a significant amount of time, and not to mention the fact when you talk about significant delays within the criminal justice system, the courts at the moment, as we all know, are at a breaking point, and effectively the amount of people waiting in prison for their trials at a 6-year high, and we have the highest prison population in Europe. Trials are currently being listed, as I'm sure we've all experienced, for 2023. So if you add 9 months onto that, with someone knowing that they may well be facing a charge at some point in the future before they're even charged, and then we add in the delay to getting to a trial, considerable stress for a lot longer. The government, of course, issued a fact sheet. They don't believe that it's going to mean that people are on bail longer. They're slightly impervious to criticism. And in particular, the bit that entertained me was that they expect police forces to continue to conduct their investigations in an expeditious manner. This expectation may seem slightly misguided in some areas, given that the average length for what someone is released under investigation for is about 228 days. And the ability to release someone without bail and on release under investigation also remains, even with this new bill. So it's still not circumventing the potential for the police to use release under investigation. They also said that victims will be included in more decisions, which of course is welcome, but that again takes time. So prior to the parliamentary debate, the Fair Trials Group, Global Criminal Watchdog, produced a report. And whilst they agreed it's in no one's interest for suspects to be released under investigation for lengthy periods, they dispute that the incentivization of pre-charge bail and the relaxation of time limits are an appropriate way to address these challenges. It also interferes with the right to be presumed innocent. And again, you're subject to conditions that considerably limit your freedom and rights without any judicial oversight, even though you're not actually formally accused of any wrongdoing. They also say that it may well be counterproductive to the aim of ensuring efficient management of investigations, and highlighting that time previously of the remand under investigation of 228 days. Instead of extending time limits, they state that there should be new time limits for individuals released under investigation, and this would incentivize more effective investigations. And I think we all know, even most people, it's a human trait. When you have a deadline, effectively you work up often until the deadline. So potentially extending this, having these longer deadlines, isn't really going to solve that issue. So this was a few quotes from the parliamentary debate, which I place up on the screen. I'm afraid that I've only been able, in relation to pre-charge bail, to select quotes from Conservative MPs, so I apologise that the views are somewhat not balanced. The debate did largely focus on the protest cartels, which we will hopefully come on to, which were poignant at that time in light of the tragic case of Sarah Everard. But the point perhaps to mention is there was some slight less scrutiny about the bail conditions, but you can see the quotes that I have there. You can see that Priti Patel references case law. Kay Richardson, it was a very tragic case of murder where the police effectively handed back the house keys to a husband who murdered his estranged wife days after he was questioned on suspicion of raping her. He then committed suicide. So that's effectively another thing that's spurring on these changes. You can see that Theresa May highlighted her concern about the 9-month extension, stating that we cannot go back to a situation where people are effectively left with their lives on hold, possibly for years, as a result of the operation of bail. So wrapping that up and moving on to public order. At the moment, I'll briefly run through what's in place at the moment. At the moment, there needs to be an advance notice on public processions. If the police want to place restrictions on a protest, they generally have to show that it may result in serious public disorder, serious damage, or serious disruption to the life of the community. And similarly, there's also a similar provision for aspects of public assemblies. In relation to prohibitions, their ability to prohibit protests and public processions is very difficult. They have to request that the relevant local authority ban a planned protest, and they can only do so if they have a serious concern about their ability to safely police the proposed march, and the local authorities must seek the consent of the Home Secretary before prohibiting a march. And in London, the Metropolitan Police must apply directly to the Home Secretary for a march to be prohibited. Static protests, and I was quite interested in the difference between the two. So the assemblies, unlike protest march, cannot be prohibited because of a general concern for public order. The police can only request a static protest is banned if they have a serious public order concern and they think it's likely to be held on private land without the permission of the landowner. The police can stop and search those who they believe are on their way to a static protest, which has been prohibited. There is, of course, a number of criminal offences that we know which could apply to protesters, including aggravated trespass and obstruction of a highway. So proposals for change. Effectively, on public processions, the bill wants to significantly lower the legal tests that must be met for the police on issuing conditions on protests. Under the bill, the police would now be able to issue conditions on protests when officers reasonably believe that they may likely become noisy enough to either cause serious disruption to an organisation or cause serious impact on bystanders. Serious impact is defined in the bill as noise that might intimidate, harass, or cause serious unease, alarm, or distress. Widening the types of conditions the police can issue on static protests is also included in the bill to match their protests, their powers relating to protest marches. And under the bill, police would be able to issue any conditions on static protests they think is necessary to prevent serious disorder, serious damage, serious disruption, significant impact, or intimidation. Amending the offence of failing to comply with a condition issued by the police on the protest. They've also done that. Effectively, currently, protesters must knowingly breach a condition. People would commit the offence now if they disobeyed a condition that they ought to have known was in force, that they knew or ought to have known was in force. So again, it significantly lowers the test. There's also a brand new provision on allowing the police to issue condition on one-person protests. So currently protests must involve at least 2 people to engage the police powers. A one-person protest could be subject to conditions based only on the likely noise it will generate or is generating. So if you're a very loud person and you want to go protest, then you should watch out, but not on likely serious public disorder, serious damage to property, or serious disruption to the life of the community. So this is probably one of the aspects that received the most media attention, which is the new offence of intentionally or recklessly causing a public nuisance. And it suggests that I think the main issue and concern that practitioners have with this is that you can see from 2C, which is highlighted, effectively any protest, any public nuisance that causes serious annoyance can now be prosecuted, and worryingly with a sentence up to 10 years. So effectively, we all need to learn to be less annoying with each other, or else we're going to get some considerable jail time. You can see how all of these have a huge impact and restrictions on our Article 10 and 11 rights, and the Good Law Project has also criticised the proposed measures affecting public order and protests as disproportionate and at risk of putting the UK at odds with its own obligations. In terms of where this stemmed from, I think it's important to actually analyse why this the police want more powers and why this wants the government wants to put this in place. And in particular, I quite enjoyed their responses. Again, they deny that it's going to impact on freedom of expression, but they cite the Extinction Rebellion 2019 April uprising in London costing over 16 million. And the issue that I think practitioners have, and I also have with this, is that things such as serious annoyance, or it depends which side that you effectively sit on. If you agree with the protesters and potentially if you were a member of Extinction Rebellion, then you may well have thought that the measures and that the protests itself was a very successful one, and it gained a lot of global attention. So effectively saying that some of the best protests in terms of some people can be the ones that do cause the most annoyance because they get the most media attention. So that was another element, I think, of where we could have punishment without crime until, of course, the bill was actually passed, and then it would be a crime. And finally, I know that time is getting on, but I did briefly just want to talk about serious violence reduction orders, so I'll do that quite quickly. The serious violence reduction orders, it's a new type of order that that is being proposed, and effectively it could apply to people convicted of violent offences. The proposal is designed to meet the Conservatives' 2019 manifesto pledge to make it much easier for officers to stop and search those convicted of knife crime. So whilst technically it's not punishment without crime, because of course a person has to commit a crime in order to be made subject to one of these orders, there's an aspect of which that we'll talk about, that people could end up being punished even though there isn't really any good reason for the police to stop them. So I'll speed through the new provisions. The first slide, this is the power for the court to make the order, the proposed test. If you need to see that conditions, so subsection 2, conditions 3 or 4 is met, and the condition in subsection 5 is met. So 3 or 4. I think this is actually very interesting because 3 deals with the individual. So if an individual has a blade or offensive weapon that was used by the offender in the commission of the offence, or they had a bladed article with them when the offence was committed. So, I mean, that would be quite obvious. If someone has a knife with them, they're obviously going to want to put this order in place. However, if it falls within 4, if you have a co-defendant, so a bladed article offensive weapon was used by another person in the commission of the offence, and the offender knew or ought to have known, or another person who committed the offence had a bladed article offensive weapon with them when the offence was committed, and the offender knew or ought to have known that that would be the case. So you could take, for example, a client who's been convicted of theft along with his co-defendant. No knife is actually used during the offence, but the co-defendant is arrested and found with a knife on him. Your client is not. The judge concludes on the balance of probabilities that your client ought to have known that his co-defendant had a knife. That's enough for a serious violence reduction order. So they also need to ensure that section 5 is met, and that is that it's necessary to make one of these orders to protect the public, protect any particular members of the public, and prevent the offender from committing offences with blades. So the court has to do, this is just, they have to do it at the time of sentence, and also I think very interestingly subsection 7 and 8, they can consider evidence led by the prosecution or anything said by the offender, and also 8, they can use anything that wouldn't have been admissible in the actual proceedings itself, so hearsay, etc. So this one is the actual duration. You can see that it's not for a period of less than 6 months and no more than 2 years. And also it doesn't take effect until they're released from custody. So this is actually what it allows to do if this order is in place, and this is where I suggest punishment without crime may well come into play. It removes the requirement for a reasonable suspicion when it comes to stop and search. So a police officer, as you can see from subsection 6, they can use reasonable force, and effectively they are allowed to search someone subject to these orders, provided they are in a public place. So no reasonable suspicion, so they don't need any sort of suspicion that they are committing crime, etc. So this obviously caused some serious concern. The government did another consultation, and effectively it's heralded as somewhat of a success, because 77.8% of people agreed that this new order should be created. But I think we have to remember that that's quite a considerable amount who didn't agree. And I think a lot of the watchdog groups, etc., there's been considerable outcry from them, because effectively it subverts existing legal safeguards on stop and search. The reasonable suspicion test for all searches is now no longer going to apply. And also, we have to remember that this is going to disproportionately affect people, because stop and search already disproportionately affects Black and minority ethnic groups, and that Black people are searched 8.9 times the rate of white people. And these disparities, effectively, it means that these orders as well, they are, given that there is this disparity, it's going to end up more predominantly affecting Black and minority ethnic groups, and effectively they are the individuals who are more likely to have these sorts of orders in place. So that concludes the talk, and I hope that all of you have enjoyed both mine and Tom's talk, and I note from the chat that a lot of people have been asking for the notes, so we will ensure to the slides to we should ensure to get those sent around. I think we have the emails of all the attendees. If there's any questions, I think obviously you're more than welcome to send them in. And yeah, I hope you enjoyed that and look forward to the next one. Is there anything, Tom, that you want to add?
No, other than everything will be available on the website, like the slides and the recording of this will be available for you to look at after the event. And yeah, we look forward to seeing you in person soon.
Excellent. Thanks so much, everyone.